Whenever we talk about criminal law, crimes come to your mind. A lot of crimes come to your mind, big, small, but you will see that there is not just murder or the theft. There are a lot of other things that are involved in the criminal law that will go, and while we go through the lecture, we'll see what kind of offenses include in the criminal law lecture. So we will talk about today in the first lecture, we'll talk about a little bit about syllabus. We'll talk a little bit about the classroom etiquette. We'll talk about what are we going to be covering, the examination expectations, what will you be seeing in the coming lectures, and what should we focus on and what should we not focus on in the criminal law lecture. Okay. These are your essential course materials. I'm assuming everyone is already enrolled with the University of London program. They have some assigned readings for you, books. They have a book of statute. Some of these, as you can see on the slide, can everybody see the slide? If you can see the slides, if you cannot see the slides, let me know. Okay, good. Thank you, Cindy. We have the textbook is called Criminal Law by William Wilson. Make sure it's the 4th edition. You always want to get the latest edition, whatever is recommended by your university, because every time there's an update, they bring out a new edition. After that, you have core statutes on criminal law. It's written by Kate Cook, Mark James, and Richard Lee. That's also one of your recommended readings from your University of London. Other than that, there's a subject guide that is highly recommended by the law school, and it is very well written. Every time you are preparing for the class or you're preparing for the exam, you will find your answers in the guide. And some of these things are very detailed, explained very in detail. Some of things you may not understand, maybe from your textbook or guide or from anywhere else, and that's what I am here for. Other than that, there are some suggested readings that I will recommend it to you slowly later on. Throughout the course, I will be giving you the tips about it. Okay, so let's see. First, okay, examination. First of all, you guys all should be aware that the examiners can or may change the format of exam anytime whenever it's deemed necessary or it's deemed necessary to them. But typically what we are seeing right now is you're required to answer 4 out of 8 questions, which I think is a good option choice. Usually you get 2 types of questions. We're going to talk a little bit about essay questions first. In short, you will be expected to give an introduction of your question. And throughout this course, we're going to be talking about how to take your exam. We're going to be practicing different hypotheticals, different problems, different scenarios, and we're going to be learning how to write an exam, actually. And essay questions, usually they test your skills, and what we do here is we're going to strengthen your skills, not just to help you learn the course, also to show you how to take an exam. For example, in the essay question, if the question asks to evaluate a particular aspect of a criminal law, it is necessary but not sufficient to merely give an account of relevant law. You should be stating the relevant law or the statute with the number and the name, but you should also be able to analyze it. You should be able to discuss whether the rule might lead to punishment, whether it is appropriate for this kind of crime or not, if it does lead to punishment, whether it is an unjust punishment or whether it is okay to punish the offender with such a punishment. Whether your punishment has a purpose, what are the justifications for the punishment that the lawmakers, whoever made that law, either your case law or the statute, what did they have in mind, what motives did they have? What is the application of the rule that results in the punishment of people who don't deserve to be punished? For example, duress, which we're going to talk about later in the course. But in short, duress is the sort of like, you can understand it as blackmailing, that you go and you kill this person, otherwise I'm going to kill your family. Or somebody is threatening you that they're going to kidnap your kids if you don't go and steal some money from the bank. That's your duress. So in those kind of situations, whether it is okay to punish the offender of murder, or he stole some money from the bank because he was afraid that his kids are going to get hurt. So should he be punished or not? If yes, why? And if no, why not? For example, recently there was a case in Texas, United States, that a man found out that his 5-year-old daughter is being raped by a 45-year-old man. And he ran and he tried to rescue his daughter. He got upset and he beat the offender to death. He was acquitted. So maybe you will be asked whether in those circumstances a person who is the murderer, in this case, should be acquitted or should be punished. If he shouldn't be punished, why or why not? Things like that. Another example could be, how is this rule appropriate? How is this rule perfect? Whether this rule is vague or not? Whether the jury will be able to extract the meaning out of it? Whether they will be able to use it to, give punishment, or to, does it conflict with the recent judicial authority? If yes, then how? And if it does conflict with it, then whether the rule should prevail or you should go with the judicial authority. Things like that. The second type of format of the questions that you will see would be problem questions, in which you will be given a scenario. You will be given a problem that you will have to see that what kind of legal advice in that situation you can give to your client, for example. Or if there's a problem or scenario, what is the offense? You have to identify the offense. You have to specify the authority that deals with that kind of offense. And if you are citing a statute, whether it's applicable. The second part is your analysis. The analysis will be that analyze the ruling with the offense committed by discussing the elements of the offense mentioned in the hypothetical problem and compare it with the elements that are mentioned in that statute that you are citing, and how those facts and those rule and elements kind of come together, and how is it that you're going to apply that particular rule to that particular problem. Also, always, when you are attempting a problem question, always think about defenses. What kind of defenses are available to your client or to the offender? If there are any defenses available, what defenses are those? And whether he can use that defense or not. Okay, we're going to go through defense and all those aspects later on in the course in detail. And also, then you also should write the conclusion in the end. Conclusion is usually whatever you have mentioned above is going to be summed up in the short format, and you're going to say what is the likely outcome would be from that proceeding that's going to be held for that offense, and whether the accused is going to be acquitted or whether he's going to be convicted, whether the jury is going to be, citing a fine and imprisonment or not, stuff like that. Okay, any questions so far? I guess not. Okay, moving on. Okay, so you have certain online resources that will help you throughout the process to get, for example, we have our Blackstone Law Facebook page set up. I hope everyone already has that on their browser. There is a link for that. Yes, you may be able to get a copy of this lecture. I'll talk about it in the end. Okay, for the people who do not have Facebook, we will be sending updates through emails as well. For example, let's say that there is an emergency and the lecture has to be moved to another day. We will be sending you an email about it. It's not going to happen. We always have a backup feature, but just for an example. And if there's anything else that needs to be done or the student needs to know, I will be sending out regular emails. So make sure you check your emails. If you don't have a Facebook, make sure you check your emails. People who are on Facebook, they will also be getting an email. And the reason we have these groups set up on Facebook is because it's easier to people to come to the group and discuss. We have a Facebook group. It's every time you're attempting an exam, there's a question from Sandeep that whether it makes a difference as far as the points go if you pick an essay or a problem question. No, I don't think it matters. I think all the questions are, they have a proportionate amount of numbers, and your exam will be telling you, make sure to read instructions if you should be doing at least 2 essay questions or at least 2 problem questions, or you should be either doing all essays or all problem questions. It all depends on your how your exam is set up. In the recent lectures that are coming up, I will be showing you some samples, and Sandeep, so you will be able to see whether what should you be prepared for. You should be prepared for essay and problem both questions because sometimes you may not have a choice, and sometimes you may want to pick an essay question because you think that you can write more about it or you have more material on it. Okay. But I'll be showing you, okay, you're welcome. I'll be showing you some samples, and we'll be doing some mock exams as well, just to prepare you guys for the exam, okay? All right, so anyway, just for the reference, the Facebook page that I spoke about, here's the link for that. Anybody want to go and join? Facebook group. Okay, to get on the email list, I'll talk about it too in a little bit. We basically have a website of wherever you get the information from the other course for the other courses. You're gonna have to go up on the website and sign up for the course. And when I have your email after the sign up, you will be getting an email from me. Yes, you are. Yeah, of course. You should be on email list, and you should be getting the emails from me too. Once the lecture is over, I will go back and check my email list again. If you are signed up for the course, I should have your email address. Okay. There are a couple of Facebook groups that I talked about. There is a main intermediate study group. There is just a criminal law group. I suggest that anyone who is on the Facebook, please go and join those because we will be holding regular discussions on these groups. You will be able to interact with me and other instructors about the courses that you have taken. Any questions you have, you can always go and post it here. You can always email it to me. I will also give you my email address. It's also on the website. And you can, anytime you have a question, feel free to tag me or feel free to send me an email. This is the group, the last link that I sent you is the group of the intermediate study group of Blackstone Law, where everyone who is enrolled in the program is going to be there hopefully, and that's where we're going to be holding a lot of discussions. Just solely for criminal law, the link that I sent you earlier, the second link, is the one that you want to be able to join. I will be posting updates, however, on all of these forums and through email as well. Other than these, you have a VLE student portal through your law school. VLE is Virtual Learning Environment, and it gives you, it's from University of London, and it gives you an access to online library and other online resources, including audio presentations, Guides is also available there online. There's a lot of good resources there from your law school. So if you're enrolled in that, in your law school program, your Institute of London, you should have the access to this portal. Okay. Any other questions before we move on? Okay, great. All right, syllabus. We will be covering a lot of the topics. Here I have mentioned some of the major topics. We're going to go in detail on these topics throughout the course. And okay, just a second, guys. Okay, we are going to be going through these all these topics throughout the course in detail. Just for an overview, we're going to read about actus reus, which is your conduct. We're going to be talking about mens rea, which is your criminal intent. We're going to be covering the major offenses like criminal homicide, its degrees, sexual offenses as rape. No, there are non-fatal offenses against the person. For example, hurting a person or giving him or her a grievous bodily harm. We're going to be covering defenses in detail. We're going to be also covering property offenses. So if somebody stole your money, if somebody stole or damaged your property, arson, somebody, set your house on fire or something like that. We're going to be covering those. There's another major topic in criminal law is the participation in crime. People who get together and commit a crime, your accomplices, your major offenders, all of those things, we're going to be covering all of those. All right, let's come to the real thing now. Who is the lawyer and what does he or she do? As far as we are concerned here, who is a criminal lawyer, right? So your training as a criminal lawyer, you should be proficient in criminal law, first of all, which means that you should know what you're dealing with. You should know what your offense is. You should know the degrees and the level of offenses. You should know your law. You should know your case law, all the updates. As a lawyer, you should know your statutes. You should know any amendments that Parliament has done in the statute. You should have the ability to use books, libraries. You should be able to explore internet. You should be able to go and research law, read law and extract meaning out of it. You should have the understanding of evidence and procedure. Although in criminal law, we will not be covering the law of evidence. It's another huge subject on its own. And we will also not be covering the criminal procedure, which is also another subject on its own. We are only concerned about criminal law, substantive criminal law in this course. Also, you should be able to see as a lawyer that what rule is going to be applicable to particular offense, and how are you going to apply that particular rule of law, that particular statute, that particular case law to the offense that's been committed. You should be able to draw logical and coherent conclusions, which means that you should be able to infer. You should be able to know that if I apply this law to this offense this way, what kind of outcome it's going to bring about. Okay, if you have a client, how this rule is going to help him, or how this particular rule is not going to help him, and whether the offense he has committed, it has some defenses that you can raise. And all of that stuff that we will also be covering later on in the lectures. Okay, now does everybody know what is a crime? We should have a regular understanding of what a crime is, right? A crime is something that you have committed, something that you shouldn't be doing in the more literal sense, more general sense actually. All right, nobody has a question here? Okay, crimes. Crimes are basically, according to your textbook definition, crimes are acts, which is something that you do, and it can also be an omission, which is something that you did not do. How is an omission a crime? You would think, right? Sometimes a law asks you to do certain things. You should be stopping on the red light, okay? You should not be stopping on the green light. You should be driving on the green light. You should be stopping on a stop sign. You should give a pedestrian a right to walk before you start driving again. Those are the things that law asks you to not do when it says that do not drive on the red light. That's what is your omission is, that if you don't, if you do what your law asks not to do, that is your omission. So not doing an act is your omission. What are crimes against? It's an act or omission against a person, either me, you, anybody else, people, or property. How can you commit a crime against the property? Well, you can vandalize somebody's house. You can go and break somebody's windows, so to speak, for example. You can steal a car, okay? That's a crime against your property. Crimes seem to be criminal under a statute. There are two ways a crime can be defined and a law can be defined, okay? For example, Parliament has enacted an act. This act, capital ACT, is different from the act that we just mentioned about what a crimes are. Actions, it's something you do. A statute is an act with capital A. It's an act of Parliament, specifically when Parliament get together and make a law, certain law. It's unlawful to cross a red light. That's your statute, for example, okay? The other way that crimes, the laws are made is through case law. In Europe or in common law, it's very, very, very common. Most of your law is made and defined and identified and changed through case law. Whenever a higher court gives a decision on something, it becomes a law. It's also called a precedent. They are very popular in Europe. They're very popular in America and every other country where they use common law. Okay. Why something should be prohibited? Why do you have laws against certain things that you shouldn't be doing certain things and you should be doing certain things? It's because it involves maybe what you are doing, what is considered a crime, is threatening or harming an individual or its property or the public interest in general. Okay. What is the public interest? Public interest is something, an interest in something, for example, peace. Peace, that we shouldn't be fighting or killing each other. Peace. It's my interest, it's your interest, it's whole America, Europe's interest that people should not be going around and killing other people. So that's your public interest, which is a common interest for all people. Conduct can be deemed criminal due to few reasons. It could be moral and also or social reasons. Some laws, like certain EU laws, morality is involved in making the law, and something if it's against somebody's morals, it doesn't necessarily have to be a crime, but there are certain things that are against morals. Maybe just few people consider it against their morals or morality, but it's still a crime. Okay. Although a crime may be committed against a specified individual, it's still classed as a public law. Why? Because when you are, for example, killing somebody, it means that if you're killing one person, the lives of other people can be endangered too. Okay? And if a murderer who has the capacity to kill, for example, one person, he may also have a capacity to kill somebody else too. So our common goal for a peaceful society is that we want to not feel less secure. We want to feel safe from the harm. If I ask you a question right now, what examples can you give me as to what constitutes a crime? Does anybody have any examples? You can write in the chat box. What would constitute a crime? No? Okay. Mens rea alone, we'll talk about it. Mens rea, your bad intention doesn't necessarily is your crime. You can have bad intentions, but it Doesn't listen. The law is not going to punish you just for hating somebody or thinking about hitting somebody. Okay. Something you do against the law, yes, it's a crime. Not fulfilling a duty of care as an example of a crime of omission. It can be, yes, an act or omission. Okay, what about you're sitting in a ball game or you're sitting in a Wimbledon watching tennis? Okay, it's very popular in UK. Against a person or property, of course. But I'm asking for a specific example. You're sitting in a game, you're watching cricket, for example. You're in a stadium watching cricket. Somebody else in the audience is booing against your team. Robbing a bank is a crime, yes. If somebody is saying, booing against your team and they're just cussing them out loud, would you think it'd be a crime? No. Why not? Not prohibited by, law does not tell you to not curse, okay? You can boo against any team you want. It's not a crime. No case law or statute against it. Yeah, it's not a crime. It's not harming physically anybody. It's not harming anyone's property. It may be hurting your feelings. It can hurt my feelings. They're booing against my team. That's true. But how you determine that something that if you don't know there's a case law about it or there's a statute about it, if I'm just going to go and screaming out loud against your team because your team is winning, my team is losing, and I'm just mad and I'm going to start booing, I'm not committing an offense. I may be hurting your feelings. My feelings are hurt too. It's nothing against that's hurting a society. Okay. How about possession of marijuana, a pot, any drug that is illegal? Or you're not using it, but you just have it in your pocket that you're going to go out and sell it into a college dormitory. Yes, it is a crime. If marijuana, if selling drugs, using drugs is prohibited in your state or in your country, depends which state you're in, of course. In Colorado, maybe not, but in the United States, but maybe in certain areas it is, yes. If it's prohibited, then yes, it's a crime. Good job. Any questions about it before we move on? Okay. All right. Now, somebody has mentioned about duty of care. Duty of care is a very important point to learn in law of torts. Everybody has a duty of care. It's a general principle of law of torts, right? You should always remember you will see certain examples of crimes that can also be tort. Okay, a crime of tort. For example, misappropriating somebody's property. I take your computer and I take it and walked away and I never return it. Okay, it can be a tort. Does it necessarily have to be punishable under criminal law? Maybe, maybe not. There are certain things that you will, for example, an accident, you're crossing the road, somebody ran the red light and it hit you and your leg hurt, okay? It's a crime, right? It is a crime. Hitting somebody when they're walking the street and running the red light, it's a crime. It is also a tort. Your contract law is another example of your private law. How you distinguish between a crime and a tort? Or crime versus tort contract is that first of all, the parties. In criminal law, you are one of the parties, but instead of the victim, the state or the country or the crown in UK is gonna file a suit against you. Okay, so your parties are your state and yourself. But in contract and tort, they are both private parties, person A and person B. It's between person A versus person B. Another thing that distinguishes your crimes with your tort or contract is the punishment versus damages. In criminal law, when you commit a crime, you always get punished by law. It's either going to be an imprisonment or fine or both. In civil law, in your public law, in your private law, damages, which is only money damages, I award it to you. You don't have an imprisonment. You don't have a community service, but you're only going to pay a fine. Or, I'm sorry, not fine, damage. You're going to pay damages to the person whose property you have taken away, and it has caused him loss of time. It has caused him all his notes that were on in his computer, and you lost his computer. That person is going to pay you money. That person maybe is going to buy you a new computer. The court may award some damages for him to recover for your notes, for your 3-year law school notes that were in that computer. So damages are awarded in tort and in contract. Imprisonment or fine or both are awarded in your criminal law. Okay? All right. Now, there are certain categories of offenses. In your book that you will read, there are 3 types of offenses. For example, there is an indictable offenses. Okay? Those are the most serious crimes, most serious offenses. It includes mere murder, manslaughter. It includes rape and robbery. It includes causing somebody a great injury to their body, a grievous bodily harm with intent. Your law puts high penalties upon conviction. You may have a life imprisonment. And to which court are you going to go and deal with these kind of offenses? You're going to go to Crown Court, and there's going to be a jury there. Okay, not just judge, but there's going to be a jury. Second, down the list comes either way offenses. Those are the seriousness is medium. The word that's used in your textbook is medium. Medium serious offenses, where facts of the particular incident will usually determine the severity of the offense, which means how serious it is the crime is. It may include your theft, your assault. You will read in the torts as well and in crimes what assault is in detail and theft. For example, occasioning an actual body harm, just hurting somebody, which is not life-threatening, but somebody is bleeding, you just beat him. Burglary, burglaring somebody's house is also either way offense. They deal with these kind of offenses in either a Crown Court or a magistrate court. Okay, the determination will be made in the magistrate court for ultimate trial venue. You go to magistrate court and they're going to decide whether is your crime serious enough to send to you Crown Court, or it's not so serious. They're just going to keep you in the magistrate court. Okay. We'll read about courts in a little bit too in a few upcoming slides. The third kind is your summary-only offenses. Those are the least serious offenses. For example, your driving felonies, driving offenses. You have a light assault and battery. These kind of offenses have lighter penalties. There may be some endorsement on your license. This takes some points off your license. There may be a short-term imprisonment, maybe a week, a month. What you do is you go to the magistrate court for that, and they deal with those cases without a jury, which means you don't have a jury trial. You don't have a right to have a jury trial. Thus, you should understand that a defendant does not always have a right to a jury trial. Okay? It's not available all the time, but it depends on the seriousness of the crime that an offender has committed. Guys are with me so far? Any questions? You will see cases, the reference of cases in your textbook as well. You have cases mentioned in your guide. There are certain books available that I can recommend to you later on to learn about cases. There are a lot of cases that are online. There's a very famous case, case of Ireland. I will. This famous case of Ireland that we're going to be given an example of throughout the course. It's a very famous case. It's mentioned in your book. Most cases, you're not going to need another extra book for the cases specifically because your book and your guide has mentioned all the cases in it. The book of statutes have also cases mentioned in it. Okay? All right. Now the hierarchy of the criminal courts. What is the hierarchy? Hierarchy is that how the courts are set up. For example, what court is your most powerful court, the most epic one? Then what comes next, and what comes next, and then which court is the least right at the bottom. Okay. So first of all, your magistrate courts. These courts have justices of peace or judges. Who is a judge? A judge is a person who is legally qualified, and he's also called a district judge. And the justice of peace is a panel. It's a bench of 3 lay judges. Lay judges means these are the judges that are not legally qualified, but they are okay enough to get on the board. Either way offenses may go to your next comes the Crown Court, and your either way offenses can go to either the Crown Court or Magistrate Court, depending on the seriousness of the crime, as you just saw. The next in line here is Crown Court. The Crown Court has a judge and a jury. We'll discuss the roles of judge and the jury later on. Your indictable offenses or your either way offenses, like I said, they go either to the Crown Court and or the Magistrate Court. After that, your Magistrate Court is, your Crown Court judge is the circuit judge who is legally qualified. There is no justice of peace within the Crown Court. After that comes your appeal tribunal against convictions from Magistrate Court. There's an appeal tribunal, okay? The defendant can go and file, submit an appeal that I don't agree with the decision, okay? Look at my case again. Then you have a court of appeals. It's a criminal division as well as the appellate division, which means that the cases that go from lower courts or Crown Court can go to appellate division, court of appeals. Then you have a high court. How cases go to the high court? They go either by case stated, it's the terminology that you guys should be aware of, or judicial review. Case stated is an appeal on the point of law only. Either you don't discuss any facts that has already been discussed in your case in the lower court already. So it's just a point of law, and alternatively, an application for judicial review of the magistrate or trial judge's decision may be made to the higher court, which means that a magistrate can give an application to from the trial judge or from the trial court that this case should go in the higher court on an appeal, or if they refuse to send an application, and then the defendant can plead or the plaintiff can plead to the higher court, and the judges in the higher court will make a decision to whether they should be reviewing this case judicially or not. Okay. Then you go to Supreme Court, which is the most epic court, the most highest court. And the appeals that go in the Supreme Court can be either from the prosecution or defense, both. And you need a leave to appeal for that. You file sign for an appeal. Something that you should know about the legal appeal, that before October 1st, 2009, appeals from the Court of Appeals were made to the House of Lords. Okay, now there is no House of Lords that deals with that. A case will only be proceeding to Supreme Court if the Court of Appeals certifies that a question of law of public importance, and they can grant a leave of appeal. If the leave of appeal is refused by Court of Appeals, an application of leave of appeal can be made directly to the Supreme Court. Okay? A party can send an application to the Supreme Court directly that the Court of Appeal is refusing to send my appeal to you, Supreme Court. So please take my appeal into my leave into consideration and grant me an appeal, and that's your leave of appeal. All right, let's talk a little bit about procedure, because when you're going to the criminal law, you should know how courts work. You should know how after a crime is committed, how it goes down to after the conviction or the acquittal. So first stage, somebody has done something bad. The crime is being committed, okay? Then there's going to be an investigation. Okay, then there's going to be an arrest. The offender is going to be charged or indicted. Then they have a first court appearance. Then you have a trial. And after the trial, we're going to discuss the trial later on as well. We'll see how the trial goes down. And then there's a verdict and sentencing, depending if the jury is giving a verdict or not. And then they decide on sentencing. The Crown Prosecution Services, which is in short as CPS, has the overall responsibility of bringing the proceedings further. They start the proceedings. It's their job to assess the weight of evidence. Whatever evidence they have, they will decide in the light of that and in the public interest that whether the prosecution should proceed, should take this person who has committed a particular crime to the court or not. Ireland is the specific example. It's the case of Ireland. Very briefly, we'll read about it later on in detail, but what happened was that a woman was receiving calls from this person, Mr. Ireland, repeatedly, over and over and over again, and he wouldn't say anything. She could only hear breathing and other stuff. So it was CPS who decided that it was enough to charge this person because that has really impacted that woman's health. It has grievously hurt her emotionally and psychologically. So they tried him and it went to the court. It's up to the CPS to see whether they should take this person or this offense to the court or not. There not necessarily has to be a connection for CPS between the offense actually committed and charged, but they decide, like I said, in the line of in the side of evidence and public interest. Sometimes they also undercharge. Sometimes, for example, the crime is serious enough, but they don't have enough evidence, maybe. Okay, so they're not going to charge you exactly for that crime. For example, they're going to cut the murder or homicide down to involuntary manslaughter, so to speak. It has a lesser punishment. Why? Why do they do that? Because sometimes they don't have enough evidence to convict this person of this crime in a way that they want to do it. Okay. For example, it's easier to prove theft than robbery because of the elements of the crime. It's easier to prove theft. Robbery is hard to prove. It may encourage a guilty plea. Okay. For example, if prosecution is going to say, look, Mr. Offender, if you plead guilty to this offense, we're going to bring the charges down, and instead of serving an imprisonment for 15 years, maybe you will only serve 5 years and do some community service, okay? Maybe they have an option to not indict him and summarily hear the case. And what are the advantages for the prosecution for summary trial? It's a shorter period. It is less costly and more efficient. Okay. It is also thought to increase the chances of conviction. You're going to convict this man quickly. You can't take a chance that he may leave the country or do something else. So you're going to indict him summarily. Or maybe sometimes you think that the evidence you have now, it may get lost or get wasted. Sometimes whatever the evidence is, depending on. So they decide they charge him and they take it to the summary court, and the summary trial is held, and he's convicted. Or she is convicted. What is the procedure once you get to the trial? We'll read about it. Theft and robbery, there is certain elements. Each crime has an element, and each crime has its own elements. The element of theft is the stealing and taking away somebody's property without their intention, for example, to keep it forever and not return it. That could be your theft, and robbery could be that breaking and entering in the night into somebody else's house with the intention of stealing their property and not giving it back. We'll read about all these offenses in detail, and I'll tell you in the later slides that how to break down the elements of offenses, and that's how you differentiate between the theft. We'll be able to differentiate between the theft and robbery. Okay, Carl? Okay. Okay. All right. So so a person is indicted. He's been charged. Prosecution is gonna go on and present the case to the court, and then the defense go on and submit that there is no case to answer. They submit their answer and they say prosecution hasn't proved all the elements. They don't have all the evidence, and they're charging my client for theft, but he doesn't have the property that they're claiming that he has stolen. Prosecution doesn't have a case, so I would like the court to dismiss the case. Okay. If the prosecution's defense, if the defense's case is presented and their successful submission has been given by the defense, then your accused is going to be acquitted. If the defense is not successful in their submission, the court is not satisfied that the defense has actually made their case that the prosecution has been unsuccessful, then it will not be acquitted and the case continues. What happens when the case and it's an optional step. Defense does not have to do that, but sometimes they do, just to try and see whether they can get their client acquitted quickly. Presentation of evidence comes next after the defense present their case. Then you have witnesses. The judge evaluates the evidence. The jury sees the evidence. The witnesses come along and they are interviewed. They are being examined. And then the arguments from both sides, prosecution and defense. And then the prosecution and defense give their closing speeches. And the judge sums up, in the Crown Court only, the judge sums up the case. Then the magistrate or the jury, they retire to consider the verdict. What does it mean to retire? It means that the jury goes out of the courtroom, they sit in the room privately, and they talk about whether this person, in light of this evidence and the jury instructions, should he be punished or not? Or should he be not punished? Because you don't have, the evidence is not, powerful enough to convict him. Whether they decide whether basically this person has committed a crime or not. The jury or the magistrate, when they come out with a non-guilty verdict, then your accused is acquitted, of course. But if they come out with a guilty verdict, then there's going to be conviction, which means he's a convict now. He's not an accused anymore. He's a convict. And after that, in the end, sentencing proceedings go on, and then the court and the jury decide that what kind of punishment the offender should be serving or the convict should be serving. How many years in imprisonment, how much fine, so on and so forth. Another very important point that you should be learning in your criminal law is the presumption of innocence, or the burden of proof. We call it the burden and the standard of proof. Okay, there's a certain thing as a presumption of innocence. The presumption is that a person is innocent until it's proven guilty. What is your burden of proof? Burden of proof is that who has the burden to prove that a person is guilty. It's always on the prosecution, always on the prosecution, to prove all the elements of crime against the defendant. And also, if the defendant has produced some defenses, this prosecution's job to disprove all the defenses that is raised by the defense. Defense does not have to prove anything. It's the job of the defense counsel to undermine prosecution's case and bring forward any defenses his client may have. Should have good defense in order for his client to be acquitted. That's a defense counsel's job. In certain circumstances, the burden of proof shifts to the defense because once you have to present a defense, you should be able to tell them that yes, this defense actually existed, and my client was completely there. For example, self-defense. If he was not going to kill that person in self-defense, he was going to kill him or his kids or his family. The burden for the prosecution is always beyond reasonable doubt. That's the standard. It's a higher standard. This is called the standard of proof. Okay? It's intentionally kept high because there's a lot at stake here, in contrast to the civil proceedings, for example, in force or contract cases. Albeit, a lot of money may be awarded, but life and liberty are always going to be at higher stake, more important than money. Also, there's another reason for this higher standard because the cases are between the state and an individual. And state has a lot of money, and since they have a lot of money, they may be able to persuade a lot of people, and they may be able to use that money to get a lot of evidence that a normal person may not be able to because of because they maybe are short of money. If the jury thinks that the prosecution has proven their case beyond a reasonable doubt, they can convict. Otherwise, they will have to acquit. If they think that they have not proven their case, they cannot convict. Okay, so what is satisfaction? You must be satisfied that you are sure. This is the instruction that's given to the jury by the judge. And they're going to go and think about whether he committed a crime or not, or whether he should be punished or not. It's called the satisfaction, and those are the instructions that are given to the jury. In courts, you must be satisfied so that you are sure is the standard instruction that's given. Shift of burden, we already talked about, is in exceptional circumstances when the burden of proof is shifted to the defense to prove that they have a good enough defense. Evidential burden, in contrast to burden of proof, evidential burden is that in a criminal trial, it's used only in criminal trial and really becomes significant when defendant relied upon certain defenses and will bear the evidential burden, which means that he should have enough evidence to prove that his defense is okay enough to prove that the prosecution doesn't have a case. It's a burden to raise some evidence in order to make an issue a live one. Okay. So, for example, they say that other than the defenses, they're going to go on and say after the prosecution present their case that they don't have a case. They are accusing my client of a murder, but he didn't have any intention. Okay. So really, there is no issue. A live one means that there should be an issue in order to proceed to the next level of the court. Okay. Any questions so far? Okay. All right, moving on. What are the elements of criminal liability? Criminal law is a substantive law. What are we going to study here? The procedure law is the law that defines the procedure, that how is the sentencing go down, for example. Substantive law is the subject, that the definitions of offenses, what are the defenses, what are the elements of crime. Those are all your substantive law. Criminal law that we are studying today, and we're going to study this is going to be your substantive law. Okay, Carl has a question that what legal dictionary should I suggest? I have always studied Black's Law Dictionary. It's great. There is a lot of online dictionaries that are very, very good, legal dictionaries. I will share later on a link for everyone that what kind of dictionary that you can use. It's free and it has a lot of good definitions for you. If any of you use iPhone or Apple devices, they have free apps too. They have free apps that you can download for legal dictionaries. I have a few on my own phone and they help. If you don't have an access to anything else, then you can just get your phone out and look at the definition real quick. Okay, so elements of criminal liability are, the major elements are accessories, this is the act, the actual act, the killing, stabbing and killing somebody is your actus reus. It's a Latin term. We're going to discuss it in detail later on in other lectures. Then comes your mens rea. Mens rea, the correct spellings are this. Sorry about the typo, I'll fix it. Mens rea means the mental element, the state, the intention. Whether the person was intending to kill this person, whether if the person wasn't intending to kill, but did he have a good enough reason to know that if I'm gonna stab this person, it's gonna cause him grievous harm or he may die. Okay, the mental state is your mens rea. Absence of defense. In order for somebody to make them liable of a crime, they should not have any defense. If they have a defense, the criminal liability is not absolute. And then again, that's how you prove your criminal liability. Very short, but we'll read about it in detail later on. All right, then, okay, so let's talk a little bit about the elements of offense in detail. I have a little example of this section. It's from Theft Act 1968. How do you know what elements of a particular crime are? Okay. Now always remember, prosecution has a burden of proof to prove all elements of crime that are present in order for the defendant to be convicted of a crime. Okay. Your Theft Act states that a person is guilty of theft if he dishonestly appropriates property belonging to another with the intent to permanently deprive the other of it. Underneath that, I have specifically written separately all the elements. So the all elements of theft would be dishonesty, appropriation of somebody's property that belongs to another, not you. And then you have an intent to permanently deprive somebody of it. Can you guys look at it for a minute and tell me which elements of this particular definition would be called mens rea, and which elements are the actus reus? You can look through it and write down in the chat box. Okay, dishonesty is yes, that's your mens rea, that's your mental state. Intent to permanently deprive, yes. Yeah. Your dishonesty and your intent to permanently deprive another of their property is your mens rea. Good job. Good job. Appropriateness. What is the appropriation of property? That's your actus reus, that's true. Taking property. Yes, Jennifer. Jennifer says taking property. Good. It's taking property. Anybody else? Taking property of. Yes. Yes. Taking property that doesn't belong to you without their permission. Of course. Yeah. You take my pen away. You don't have my permission. You pick up my pen and you like it. You're never going to return it. You don't intend to return it. You take it away. That's your theft. Okay. You stole my pen. Good job. The easier way to separate mens rea from actus reus when you are describing the elements of crime in your exam is to separate your mens rea define them separately, and whatever is left is your actus reus. What do you think is the burden of proof here? If I ask you, what does the prosecution need to prove here? Yes, beyond a reasonable doubt, but what do they have to prove? Yes, exactly. They have to prove everything with certainty, beyond a reasonable doubt. They should be sure, for sure, that he was being dishonest, okay? He took his property with the intention that he's never gonna give it back. And once they prove all of it, then it's the liability. We're running out of time, and I have a few more questions for you. Keep an eye out for the questions. I'm just gonna post these questions on the group, and maybe it will start a little conversation with you guys. And you just discuss it. We're gonna take this particular example. I post the example, and I'll post just a few questions. It's gonna stimulate your mind a little bit and give you a head start on the lectures later on. And then I will also discuss it with you. I'll come back and check quickly whatever you guys have written, and then we'll discuss just a couple of more interesting questions. And there's a conclusion. Always remember, you have to identify the crime, you identify the rules, you identify the parties, you should be able to understand what actually is the problem or fact here. You apply the rule, you identify the burden of proof, or whether it's been met or not. You identify the defense, you identify the liability, and then you identify the punishment, if applicable, and you tell them that they could be punished or not, so on and so forth. Okay, I'm gonna end the lecture here, but I'm gonna leave it on for a while. If you guys want to talk to each other, go on. And in the meanwhile, I'm just gonna prepare some questions for you online, and whoever has the access, we can go online and check. Yes, that's what I was intending to do. I will email you. If you don't have the Facebook, I can email it to you. Is that okay? Okay. All right. Both ways. Oh, yeah. I was gonna. If anybody doesn't have a Facebook, I will email these questions to you, to everyone who is signed up for the criminal law list, criminal law lecture, and to take that lecture. Anybody who has been joined from the contract law, thank you for coming. And if you think that this is the course for you, please go on and sign up for the next lecture. And the schedule is posted online. Everything is posted online, and I will see everybody, hopefully, whoever was here, next Saturday. Again, if you have any questions, here's my email. If you have any questions, send an email. Tag me on Facebook if you have any questions in the group. Ask me. If you want to give feedback about the lecture, how was it? Did you understand? Did you not understand? What do you think you should? Yeah, I'm going to post a dictionary link, and I'm going to email it to you. I'm going to post it in detail, and I'm going to email it to all of you. Yes, indeed? Okay. And go on and email me, give me feedback, and I will see you guys next week. Bye. Have a great one. Thank you.